Can an employee successfully claim discrimination under the Americans with Disabilities Act if they can't prove that their disability was the reason for their employer's adverse actions? This question was at the heart of the landmark case of Chalfant vs. Titan Distribution Inc. The story begins with Mr. Chalfant, the plaintiff, who finds himself in the challenging position of establishing a prima facie case under the Americans with Disabilities Act, or ADA. To cross this threshold, Chalfant must prove three things. 1. That he has a disability as defined by the ADA. 2. That he's qualified to carry out the essential functions of his job. And 3. That he suffered an adverse employment action due to his disability. But the complexity of this case doesn't stop there. Chalfant also brings forth claims under the Age Discrimination in Employment Act and the Iowa Civil Rights Act. This means navigating the intricate interplay between federal and state laws. Then, we come to punitive damages, reserved for cases where the employer's conduct is especially malicious or recklessly indifferent to the federally protected rights of the employee. In Chalfant's situation, the court must consider whether Titan Distribution's actions rise to this level of culpability. The evidence must show that Titan acted with a conscious disregard or with deliberate indifference to Chalfant's rights under the ADA. The Eighth Circuit's precedent indicates that punitive damages can be awarded if the plaintiff establishes that the employer acted with malice or reckless indifference. But the determination of punitive damages also hinges on the employer's knowledge and conduct. If Titan Distribution knew of the discriminatory conduct and condoned it, or if the discrimination was part of the company's standard operating procedure, this could justify punitive damages. In the end, for Chalfant to succeed in his ADA claim, he must convincingly argue that his disability was the reason for the adverse employment action. As for punitive damages, they would be deemed appropriate if it can be proven that Titan Distribution's conduct was malicious or showed reckless indifference to Chalfant's rights. The legal framework provided by Miller's text underscores the importance of a thorough understanding of the ADA's requirements and the legal standards for punitive damages in employment discrimination cases. The outcome of such cases often rests on the ability to present a compelling narrative that aligns with the legal criteria for both compensatory and punitive remedies. So the question remains, can Chalfant successfully claim discrimination and win punitive damages? Only a deep dive into the intricacies of the ADA, the ADEA, and the ICRA, along with a compelling narrative, can truly answer that.